Hebrew University here in Israel. Rotem's research focuses on the history of the laws of war and of human rights. He published in the European Journal of International Law, the International History Review, and elsewhere. So please.
Sorry about that. And I must also start with an apology. Nothing involved the night travel, but it involved a morning in which anything that could go wrong in Jerusalem went wrong in Jerusalem. I really apologize for being late to you and to my colleagues to this panel. I would like to speak today למטה Jewish Yearbook, PowerPoint Jewish Yearbook. Excellent. Today I'd like to speak to you about the Jewish Yearbook of International Law. You may know that the 1948 volume of the Jewish Yearbook of International Law appeared in April 1949. It was printed in Jerusalem. Civil strife, siege, and war all delayed the publication. In February of 1948, a car bomb exploded in front of the offices of the Jerusalem press. The fire consumed some of the manuscripts which the editors left there a few hours earlier. The Jewish Yearbook was written in English, not in Hebrew. It aimed at readership that went beyond the local. And reception was quite favorable. There were positive reviews in the Yellow Journal, the American Journal of International Law, International Law Quarterly. The first volume, per the reviewers, was an important service to the advancement of legal scholarship. It was a significant event. The reviewers didn't mind that some of the materials were not original, and that events made some of the contributions a bit outdated. But the first volume of the Jewish Yearbook of International Law would also be its last. Why Jewish Yearbook? Why a Jewish Yearbook of International Law? What was to be its function? Who were to be the readers and the contributors? Why did it come into being when it did? Why was it discontinued? What room was there for a Jewish engagement with international law after the Holocaust or after the establishment of the Jewish state in 1949? Today I would like to try answer, or at least offer preliminary answers to some of these questions. And I would like to start with the function of the Jewish Yearbook. The function of the first volume of the Jewish Yearbook was to record the past. This was not the original plan. In late 1946, the editors, Nathan Feinberg, Jacob Stoyanovsky, conceived of a scientific platform dedicated to an inquiry into the problems of the Jewish people from the perspective of international law. So this was not to focus on the past. The purpose of the Jewish Yearbook, according to the editor's introduction in the actual first volume, was to finally redress the need for a periodical publication devoted mainly to the study of questions of international law affecting the Jewish people. But the purpose of the first volume, however, was to take stock of the past. It was an attempt to sum up the unique position of the Jewish people in international law. So the plan of the first volume was conceived, the editors wrote, with an eye to the past rather than to the future. The editors, in fact, were almost ready to concede that focusing on the past was not at all that useful. In the meantime, the editors trust that some useful purpose will have been served by the publication of the present volume. What made them pronounce the first volume already obsolete? Well, that was the present. The editors were acutely aware that they were witnessing a transition. In the past, they wrote, the Jewish people at all the time were mainly the object, never the subject of international law. What kind of object were they? On the negative side of things, they were the object of discrimination and repression. Even on the positive side of things, the Jewish people were no more than passive objects, not masters of their own fate. The object of international conferences, of diplomatic notes, of humanitarian intervention, etc. So the Jews were the object of protection, but this protection attested and affirmed their inferior status. The present, however, was radically different. Before the establishment of the State of Israel, the editors wrote, the Jewish people could not have been anything else. Now, they were the subjects of international law. Jewish independence in 1948 meant Jewish sovereign equality. It meant that Jews were possessors of rights, not just recipients of benevolent charity. It meant equal legal standing, in short, an end to inferior political and legal status. Indeed, what the editors stressed in the first essay of the volume, dealing with Israel's Declaration of Independence, was the separate and equal station, a phrase that our Declaration of Independence borrowed from the American one. Along those terms, these are the very notions that Moshe Sharet, a first foreign minister, expresses in his maiden speech before the United Nations General Assembly in 1949, right after Israel's admission to the UN. Transition from inferiority to equal status, from passive protest to active responsibility, from exclusion to membership. So the establishment of the State of Israel changed how international law dealt with the Jewish people. It transformed the legal status of the Jewish people in international law. And so, for the editors, summing up the past was meant to set it apart from the present. Let's look at the contributors. Who were they? Well, they were all men. They were all born Jewish. One of them converted later. Most were Zionists, or at least had some sympathy to the Jewish national revival in Palestine. All had law degrees, PhDs from Vienna, Rome, Paris, LLDs from London, SJDs from Harvard. They were barristers, solicitors, activists, practitioners, scholars. Some already taught at the Hague Academy of International Law. Some would do so in a few years. Many were old hands of Jewish politics, advocacy, and diplomacy. None was living in the country of his birth. Their biographies were an illustration of Jewish persecution, displacement, and annihilation. The works and the contributions to the Jewish Yearbook help us sketch an inventory of Jewish engagement with international law since the late 19th century. And broadly speaking, those contributors presented three different solutions to the Jewish question. Each solution assigned a different role to international law. The first solution was assimilation. There were two full-length articles in the Jewish Yearbook, written by a former teacher and his former student at the University of Vienna. Each would be described, in his turn, the greatest international lawyer of the 20th century. They were the big names that the editors could master. The teacher, Hans Kelsen, wrote perhaps the least Jewish contribution to the yearbook. The student, Hersch Lauterpacht, wrote on the nationality of the nationalized persons. The personal solution to the Jewish question was individual, assimilation or integration. Kelsen, I remind you, converted to Catholicism in 1907. Lauterpacht had some Zionist leanings or sympathies, but he made England his home. For both, however, the universality of international law could play a part in the solution of the Jewish question. For Kelsen, world order based on positive law. For Hersch Lauterpacht, universal human rights. Each of these general solutions could also help answer the particular Jewish question. So that was one answer. Second answer was collective, focused on autonomism. The second solution to the Jewish question relied on international law to protect separate Jewish existence in the diaspora. This was the solution underpinning the League of Nations minority system and the Jewish investment in its success. Here we see some of the contributors intimately familiar with the minority system of the League of Nations, represented perhaps best by Jacob Robinson, who wrote the piece on the minority system and the transition to human rights. One of these was Sefton Wilfrid David Rosen, the last in this list. I shall come back to him in a few minutes. The third solution to the Jewish problem, or the Jewish question, was collective also, but it focused on territory. It prescribed a national solution to the Jewish question in Palestine. It negated, actually, however, Jewish existence in the diaspora. It resented minority status and international law protection and the legal political inferiority this implied. Zionism sought to transform the legal status of the Jewish people and make them full-fledged subjects of international law. So the role Zionism assigned to international law was recognition. The Basel Program, the 1897 the resolution of the First Zionist Congress read, Zionism seeks to establish a home for the Jewish people in Palestine, secured under public law. And we can see some of the contributions focusing on the Palestine mandate, different expressions of Zionism, and the role of international law there. In the Jewish Yearbook, the first volume, there were also signs of the future. What would be the terms of Jewish engagement with international law after 1948? Here the editors would not speculate. They refused to turn their eye to the future. They could not foresee it. But for all the caution, the disillusionment with international law was visible. Take, for example, minority protection. At the United Nations, it was already associated with the failure of the League of Nations. Nobody spoke about minorities anymore. In Jewish circles, the failure of the minority system marked the failure of international law to protect the Jewish people against genocide. In the Jewish Yearbook, Jacob Robinson, who made the contribution, already marked the shift from protection of minorities to promotion of human rights. In 1943, he co-edited a book titled Were the Minorities Treaties a Failure? Now, his scholarship may have continued to defend the minority system for some time, but in private he realized that as a political program it was unrealistic and even harmful. In 1943, he called on the World Jewish Congress to abandon minority rights in favor of an exclusive focus on Palestine. He soon practiced that himself, leaving his position at the World Jewish Congress Research Institute, becoming the legal advisor of Israel's UN mission in 1948. After 1948, minority protection was simply incompatible with the transformation in the legal status of the Jewish people. Disillusionment also emanated from the Palestine question. First, the League of Nations failed to hold the mandatory power of Britain accountable to the provisions of the mandate, the national home provisions of the mandate. The UN was a source of recognition. It created the State of Israel, as some of the editors and some of the contributors marked, partition resolution and all that. But at the same time, there was disillusion simply because the UN failed to protect the new states which it established. And so the result was ambivalence. For the editors and many of the contributors, the lessons of past Jewish engagement with international law was disillusionment, because international law could not be relied on to provide the answer to the Jewish question. From a Zionist perspective, international law had done its part. First, the creation of British mandate. Second, the establishment of the State of Israel. And in the next 10 to 20 years, this disillusionment with the international law, this ambivalence with the international law, would be practiced by Israel lawyers, diplomats, when representing Israel, Jacob Robinson at the UN, and Sefton Rosen, who changed his name in 1948 to Shabtai Rosen and became the first legal advisor to Israel's Ministry of Foreign Affairs. I'll stop here. Thank you very much.